Gwilym, how are you, mate? I was gonna say it's been a little while, but it was only last week we did our last one, so it's not been that long.
Well, we had one that didn't happen. We need to redo that
Oh,
one.
we did have one that didn't happen, did we? Our guest got caught on a train somewhere, and
It
and we
doesn't
didn't
work
do the
on
recording.
trains.
So it's just after lunchtime. Where are you, mate?
I'm working from home today.
You're working from home. Okay, that's,
Yeah.
that's quite good. Yeah. Is that your home? I can see behind you.
Yes, yes. It's a backdrop. Well,
Very well stocked bar, if I may say so.
screensaver,
Screensaver.
screensaver.
Okay, perfect,
That's
perfect.
what it
Yeah.
is. Thank you, thanks, Lee. Thank you.
It's all right. You up to anything interesting apart from sitting in front of a really nice screensaver?
Yeah, I am working jolly hard, and I've betrayed us, Lee. I've betrayed us.
Well, you betrayed me with Neil. So where have you betrayed me now then?
I've been listening to a competing podcast.
Oh, go on. Tell me all about it.
Yeah, and what I've learned from this alternative podcast is that we don't talk about cameras enough.
Cameras.
Yeah, they talk about cameras the whole time.
Why?
Is a podcast about cameras.
Oh, okay. That would make some sense then, wouldn't it? Are you a photographer then? I didn't know that.
No, 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 no. Somebody said you must listen to this. I listened to it. I thought I don't do cameras, but no. But I just realised that there's podcasts out there that talk about cameras, and you got to learn from what the competition's up to.
I've become weirdly addicted to the Al Murray and James Holland podcast on the Second World War. And I had no interest in the Second World War whatsoever. And I stumbled across it. I thought I'd give it a listen. And I think I've gone through about 60 podcasts in the past couple of weeks.
Oh, Al Murray's a clever bloke. I saw him
Oh,
once
isn't he
doing.
just?
He also does his act in German, so
He
he's
does, yes.
yeah, that's
Yeah.
remarkable. No, he's quite good. Did they talk about cameras? Probably not.
No.
No, that's what we need to learn.
The German connection is quite interesting though, given what we're talking about today, of course.
Oh, that is beautiful. I don't know how you do it.
Oh, it's almost like I do this for a living, isn't it? It's
I don't know
almost
how
like I
you
do it
do
for a
it.
living. Yeah.
Lee Davis and Gwilym Roberts are the two IPs in a pod, and you are listening to a podcast on intellectual property, brought to you by the Chartered Institute of Patent Attorneys.
So, of course, we're going to be talking about the Unified Patent Court, which has been going for just short of a year now, hasn't it? It's must be cracking on towards an anniversary. Surely some celebration there. And I was wondering how to introduce our guest. I don't know how to introduce a guest, so I'm going to get him to introduce himself. But I was going to say one of the architects of the UPC. Would that be right, Kevin?
I'm not sure. One of the person who has devoted 17 years of his life on the UPC project. So if that makes me an architect, Lee, I'm an architect.
Okay, well let's have you as an architect. A really, really great pleasure to have on Kevin Mooney. So Kevin, introduce yourself to anyone who, for whatever reason, has missed you in your career and doesn't know you.
Well, I'm a solicitor. I'm a partner still at Simmons and Simmons. I've been there for in excess of 55 years, which either makes me very pleased with my career prospects at the firm or exceedingly boring. Some people take the view that it's the latter. But anyway, I've been at the firm for a very, very long time. And whilst I was president of EPLAW, which I think you've probably heard of, the European Patent Lawyers Association, I got sucked into the UPC project. And as I say, this was about 17, 18 years ago. And in various positions, I've been involved in the project ever since, and I still am. Hence 4.5 hours of Zooms this morning.
Oh, was that all UPC stuff?
It's all UPC stuff. It's mostly a bit of firefighting because we've had problems since the CMS has gone live, but it's also looking at improvements as well.
And it's early days. There's always going to be room for improvement, isn't there?
Well, that's right. I mean, I got involved in helping the creation of the CMS some time ago, but I ignored my son's advice. I apologize for this because there's a little bit of bad language, but my son runs IT systems, big IT systems for the BBC. And he says, Dad, listen, this was a few years ago. He said, Dad, listen, you may think you've got the perfect IT system. You may think it's, unlike Horizon, extremely robust. But when you release it to the public, then the shit hits the fan.
Yeah.
And what we've been seeing is a number of problems. Not all the CMS You know, the lawyers don't know how to work it. The judges have got their own ways of working it. But there have been some problems, and that's what we're doing at the moment. We're doing quite a lot of firefighting and some improving, I have to say.
Yeah, and it doesn't matter, does it, how many promises you get from techie people in advance of something launching. So I'll tell my little story here. Nearly 20 years ago, I launched a teacher regulation system in further education colleges, and this had to go live. The government wanted it to go live at 1 minute past midnight on the 1st of September 2007. That was when it had to go live. So now, bearing in mind an IT project that's going to register about 185,000 teachers in a few weeks is quite a large project, and you're working with these people for many months to get it ready. So, and they assured us that it would go live at 1 minute past midnight, and then we're at the kind of the final meeting, last day of August, getting ready to launch this, and it will go live. Oh yeah, we will make it live at 1 minute past. But you do realise it takes 48 hours for it to populate the internet. What?
Yeah.
So why didn't you do it 48 hours ago?
Yeah. There are these strange things called bugs. You know, I'm not terribly IT proficient. And my job, because I know the rules of procedure, I chaired the group that prepared them. My job was to work with the IT guys creating the CMS to ensure that the rules were reflected in what they were doing on the IT system. So I would sit down and analyze with them the rules and how they should be implemented, you know, because you've got a binary system doesn't easily take account of discretions. But anyway, we won't go into that. Anyway, so we'd analyze it, and then it would go off to the techie people to take our analysis and configure it. And then they'd say, okay, we can release it now into a more or less complete environment. Bugs. You know, you think you've done the job, but no, bugs.
And you probably couldn't have a more rigorous audience that you're launching it to than a bunch of patent attorneys and other lawyers, could you? They're gonna find those bugs.
Oh, and they do. They do.
And we do like to complain as well. So
I didn't say that. I didn't say that.
We love a good complaint.
Yes, you do. You like to complain. There was that sunrise period when patent attorneys were filing opt-outs, and I used to get something like 250 emails a day from patent attorneys saying, help, I don't know how to do this, etc., etc. But there we go. I love you, actually, Gwilym.
Well, everyone loves Gwilym, because, you know.
we were just helping with continuous improvements. That's funny. But the IT, didn't it start at the Brits were going to be doing the IT, weren't they? That was part of the kind of Brexit fallout, was that shifted from the UK, is that right?
No, the Brits started the IT, you're absolutely right. And they decided to go for this workflow system, which the Italians have devised. And when I became involved, all of that was set in stone, all the contracts had been placed. But subsequently, and this was before we withdrew from the project, the IT systems was passed over to Luxembourg, and Luxembourg are now responsible. Okay. Yeah.
And you're clearly still closely involved. Through what mechanism are you closely involved? That's quite interesting. Is it just because they just can't do it without you?
Right. I'm not going to answer that. Well, there have been problems, and because I was involved in the initial analysis for the CMS, they think I'm a logical person to stay involved, particularly as I do know a bit about the rules of procedure. So we have regular meetings, myself and the Italian designers of the CMS, and also judges of the UPC court who want to become involved and take decisions.
It's becoming, I mean, it's fit for purpose. I mean, there's a few interesting, it's obviously not perfect yet, but people are able to get the information they want. There's an interesting debate, wasn't there, about what information should be available from it anyway, isn't that right?
There's always that, yes.
Yeah.
And what access should be given to the information on the CMS. These are all still live issues. I think the major complaint, frankly, Gwilym and Lee, has been that some of the judges, particularly the German judges, but this was also a complaint voiced by Robin Jacob, actually, is that the workflow system is too restrictive. I mean, the way it works is that the CMS system leads you through the action. If it's an infringement or revocation, it doesn't matter. It leads you through it step by step in accordance with the rules of procedure. And a lot of the German judges are saying, well, we don't want to be dictated to as to what step follows what step. And they want to do things out of order. And they also want to do things that aren't on the CMS at all. So the major complaint is that it lacks flexibility. It's a bit of a straitjacket. And we are looking at that, or rather the UPC court with the Italian designers are looking at that to make it less prescriptive, less of a straitjacket.
We've been I think presented quite regularly as the world's first ever genuinely virtual court, as it were, in terms of the availability. And it is kind of living up to that banner, isn't it?
It is. I mean, there are a lot of things about the CMS that people like, and it is complex. You can't get away from that. All the other attempts that I'm aware of in various jurisdictions to have a real IT litigation system have failed. So it's perhaps not surprising that we run into problems. But as I say, the view is that perhaps it's too restrictive at the moment, and that is being looked at. And I think it will be dealt with positively.
So we kicked off on the 1st of June last year, I think, give or take a sunrise period. As Lee says, we're heading inexorably towards an anniversary. As you're an architect, as a dreamer, and the leader of it through Epilor and so on, and still, frankly, clearly very important to it. How are you feeling about it? How's it gone?
Oh, I like the word dreamer. Can I latch on to that one? Well, the bottom line is that we've had more cases than I'd hoped and less than I'd feared. So I'm happy. And the number, if I just refer very briefly to some boring statistics, the number of cases are actually quite impressive within that period. We've had approximately 80 infringement actions. We've got 25, 26 revocation actions, and there have been provisional measures and saisies across a number of divisions. So I'm pretty happy that we've got a variety of cases in a variety of divisions. My own firm has got about 8 active cases going, and my colleagues, my partners, are very happy with the way they're going, more or less. And more importantly, their clients are. So, yeah, I'm pretty happy with the way it goes. And I hate quoting competitors, but I'll just quote one, if I may, which is our friends over at Herbert Smith. Oh, quote friends, unquote, over at Herbert Smith, who says the UPC has got off to a roaring start. That's a direct quotation from them in a publication. And I think, that's pretty good, actually.
You mentioned the hope versus fear, and that's quite interesting.
Yeah.
I guess you hoped for good uptake, but you were concerned about potential overload. Is that the concern that you had?
Exactly right. I mean, there are a relatively limited number of trained judges, and the fear was that the courts would be overloaded. And in the first year, we would show that we couldn't keep to the very strict timetables that we wanted to impose. And that was our major fear. It would prove to be too popular almost.
And in terms of those excellent judges, so just personal declaration, I've said throughout that the UPC will work because there's great judges who want it to work. And I think we know we're lucky in Europe to have that kind of strength and depth. Are there some judges twiddling their thumbs outside Germany? That's an interesting intro to a long question, basically.
Yeah, some of them are. And the other problem, let's deal with the problems of German success, if we can call it that. The problems are that some of the judges in the German divisions are overloaded. And also the other potential problem is that, as you know, there must be a third non-German judge and a technically qualified judge. And that third, the number of third judges that are available to us to speak in fluent German, because most of the cases at the moment in Germany are in German language, are limited. So the German, we were fearful about the German courts being overloaded. On the other hand, some of the courts that we thought, the divisions that we thought would be very popular, for example, the Dutch, are not overloaded at all. The Dutch division has only had 3 cases, which is very surprising because I know them well. The judges in the division in the Netherlands are excellent. They speak English, they welcome proceedings in English, and we thought that the Netherlands would be a popular local division. And it's interesting, actually, because they had a meeting recently, judges and lawyers in the Netherlands, and saying, well, why have we only got 3 cases? I'm not quite sure that they came to a definite conclusion, but there was a feeling that perhaps we're not perceived as being patentee friendly. And that was something that I've heard expressed from the Netherlands.
Those perceptions are interesting. I don't think it's a great surprise that it's very heavily German oriented at the moment. With the UK dropping out, we were always kind of the counterbalance in a sense in terms of kind of IP superpowers in Europe. So you can see why the shift would have potentially happened. I wonder if, well, what do you think is a leading question? Hang on, how to unlead this question? Is that going to be a problem? the perception that it's very German.
I don't honestly know. I agree with you that once the Brits withdrew, there was a perception, I'll put it no higher than that the UPC was now a German project. And there was some basis for that because, to do them credit, they poured a lot of resources into the preparatory work. And as you know, a number of their judges are appointed to significant positions. I don't know whether that dominance will continue. In a sense, it reflects the position before the UPC because, you know, whereas the UK had 50 cases, 60 cases a year in the High Court, and French was more or less the same. In Germany, they had hundreds. So a part of it is a reflection of what was there before. I hope it'll balance out, and I hope that the other divisions will attract more cases later. I really do.
And obviously, one of the reasons Germany is seen as patentee friendly against, let's say, the Netherlands. I actually don't know how the Netherlands system works. But obviously, the bifurcation story has always been that breakup between dealing with the 2 aspects of a patent case always fell in favour of the patentee because of the potentially subtly different interpretations of the claim that you could run before, etc., etc.
Well, there's also a timing thing. You could get a decision on infringement long before you could get a decision on validity.
Yeah.
So that was the real driver, I think, for infringement actions in Germany.
Do you think that's going to resolve, or are we going to see a maintenance of effectively what gives rise to the patentee-friendly reputation?
They are definitely friendly. That's a clear perception at the moment. I mean, if you look at the number of infringement cases, I said about 80, 54 of the 80 are in 3 German divisions. And there's no doubt if you read the decisions that are coming out, they're mostly procedural or provisional measures at this stage, but the decisions that are coming out are certainly, they seem to me to be pro-patentee. And that may be deliberate. They want to attract the work.
Which always worried me a little bit, the idea of competitions between courts. Competitions on efficiency, on fairness, I get, but competitions on attracting certain markets, it always seems slightly at odds with the principles underlying the justice system. Is that concern?
Only enforce valid patents, I agree. But it's more or less inevitable. There will be competition between divisions. And, you know, certain of the German divisions, certain of the German courts, the German national courts have always had a reputation for being pro-patentee. Yeah.
I do think the UK is competing I gather that we're pretty busy in the UK courts, irrespective of all of this. Do you find that are you hearing the same news?
Yeah, the UK courts are still reasonably busy. I think it'd be very interesting at the end of this year to look at the UPC stats and then to look at the national stats to see if anything has changed. But, my colleagues who are still active in the UK say, yeah, the UK courts are still reasonably busy.
That's a good balance. I think we need to have that choice. And if the UPC is at least currently sitting towards Germany, then alternative fora are always going to be attractive. A couple of questions on where the UPC was supposed to sit, but perhaps some of the predictions that were a little less optimistic about it. I seem to recall that the target audience, as it were, for the UPC was always the SME, to provide that kind of value for money, as it were, in the patent litigation. Do you think that's something we're seeing happening?
Only to some extent. I mean, most of the cases that have been high profile in the UPC so far have involved companies, patentees, defendants who you couldn't describe as SMEs. I mean, for example, we've had Sanofi and Amgen, NEC and TCL, Panasonic and those. I'm only personally aware of one case which involves two SMEs, and that's in the Netherlands. So I think the hope was that the UPC would attract the big litigators as well as the SMEs. And at the moment, I think the balance is in favour of the big litigators rather than the SMEs.
It's not detrimental to the SMEs. I mean, it's just a forum they've not
No,
chosen to take.
no, on the contrary.
Yeah.
In the SME case, which I know about, in the Netherlands, the defendant tactically, but perhaps wisely, I don't know, they decided to ask for security for costs. And they asked for a relatively vast amount of money, which would have completely and utterly made the litigation unworkable for the claimant. And the court in the Netherlands said, no, we're not going to do it. We're not going to order it. So I think the court will be SME friendly, but we haven't had enough cases yet, Quillam.
No, that makes sense. And I think it needs to cut both ways. I think when you get to SMEs, there's a finer balance between patentee friendly and third party friendly. So we all want to see the courts finding a nice position in between those two. Which takes me to the pessimist's comment on the UPC, which is that it would be a troll playground. And just by way of context, Lee and I had the License on Termination Network on a previous podcast.
We did.
We did. And as you remember, Lee, they were very interested in the potential attractiveness of the UPC to non-practicing entities because, of course, they can assert so powerfully, so centrally. How do you think that's playing out, Kevin?
I haven't seen, maybe somebody may tell me I'm wrong, but I haven't seen non-practicing entities so far. I mean, you wouldn't call Panasonic a non-practicing entity or NEC a non-practicing entity. These are the
I don't think we're not going to call anyone a non-practicing entity on this podcast. Just to be clear.
Okay. I haven't seen much activity. I was, of course, aware of the concern, but I haven't seen too much of it, frankly.
Let's wait and see. Yeah, there was actually, weirdly, I think a report literally today on Intellectual Asset magazine about, I think, a troll filing. So maybe it's just beginning now. They've been
I think it
waiting.
may be just.
Yeah. Keeping an eye out. But
it'd be interesting also, just a comment. One of the things which has puzzled me has been the reluctance of US-based patentees, claimants, to start proceedings. It's quite marked, actually. I mean, as you know, there were over 500,000 opt-outs. And I've got the figure somewhere. Do you know that 32.6% of opt-outs were filed by US companies? And what that seems to indicate to me is a reluctance to participate in the court until they see how it works, how certain they are. So it's not surprising that US companies are not really appearing in the litigation sphere so far. Perhaps when they do, we'll see more trolls, or whatever you want to call them.
And I mean, that uptake isn't that surprising. If you look at almost every new IP system, look at the PCT, which had incredibly flat uptake at the beginning, and now, of course, is completely the first choice of where you're going to go with your international patent prosecution strategy. So I think the IP world is naturally quite conservative, I think. And you've got a few mavericks to go for it early. So it's not that far from characteristic.
No, I think that this number of cases at this stage in its life is, how can I put it, healthy and encouraging. We don't want the number of cases to increase too quickly, because it will undoubtedly create tensions on, just the number of judges that are available, and most importantly of all, on the timelines that we're trying to keep.
So I've got a couple more anarchy questions, Lee.
Oh, you crack on, mate. I've got a couple of questions. I will come in at some point on this podcast. Don't worry. But I've got a very long question to ask, so it probably is best saved towards the end.
Cool. So I'll go on I'll stay geek for a minute. Just two other ones actually. First, a kind of a slightly gossipy one, which is that we are hearing that the UPC has had such an impact in Germany, in particular, that some of the local German level divisions have shut down. I think one in Munich and one in Mannheim. Have you heard about that potential impact on the profession?
No, I haven't. No, I haven't.
What would you think? Is that surprising? I mean, basically, the German market share is shifting from national litigation to UPC, but I guess it makes sense that you'd have that kind of impact.
Well, I would expect to have some impact, and given the number of cases that have been focused on Germany, it would be surprising if it didn't have an impact. But no, I've not heard that chambers of the local chambers of the court of the local courts in Germany have been shutting down.
I'm relying on our president, Matt Dixon, who's the most statistically magnificent human being I've ever met. Those are facts because they came from Matt the Stat, basically.
Okay, I'll keep an eye out for that. But
yeah. And my final geeky question, actually, is just on jurisprudence and where we think possibly the law might potentially sit in terms of EPO impact and also the impact of national law, or is it just going to go German?
Well, it can't just go German. One of the things that, as you know, the rules of procedure, which are meant to be applied by all divisions, was a combination of common law traditions and civil law traditions, and that was deliberately so. We took a bit from the common law, a bit from the civil law, in the hope, rather pompously, that we were creating a great racehorse rather than a camel. I mean, some people take the view that the rules of procedure are more camel-like than racehorse, but no, that's the way we went. And I would be very disappointed if it was dominated by, in the future, by any German national law approaches or Netherlands. I mean, looking at what's happening at the moment, I'm still pretty happy that they're applying the rules of procedure and the law that has to be provided, because in the agreement there's a hierarchy of laws in terms of their importance to the court, and national law comes bottom. So I'm pretty pleased that the court is applying the rules of procedure and the provisions of the agreement fairly. But it's a great shame that the UK isn't there. Great shame.
Well, and I do hope that some of the kind of very British, so the UK-ish elements that were built in at the beginning don't get lost like they did with the EPC, where we have all kinds of quite British things hidden away in the background of the EPC that never get used, funnily enough.
Right.
So I was going to, before I finish the geekiness and hand back to Leo, just one other question, which is that you obviously you're in charge, president of EP Law at the relevant time, and you ran with this, but for 17 years on, post-Brexit, and after 55 years in the business, you're still heavily involved and centrally involved by the sound of it. Why the passion? What drove you to get so involved in this?
I'm not sure it's passion. My wife complains that I've never been heard to use the word no. And I think that's probably as good an explanation as I can give.
That's very humble. I think it's a bit more than that, personally. I think wherever you look, I think they should have called it the we did a webinar with Alexander Ramsey, isn't it?
Yes.
Yeah.
And we're saying that, if there's ever a road that one of the courts is on, it should be called Ramsey Strasse. But I do think we should also have the Mooney Building at some point, by the same token.
We're back to architects, are we? I wonder what it would look like.
Back to you, Lee.
You done with all the geeky stuff, mate?
Oh yeah, I'm geeked out.
I have a question for you, Kevin. But don't worry, it's going to have the longest introduction ever. But you don't need to worry about the introduction. I just wanted to do a bit of storytelling to get to my question, because I was thinking about lots of things in preparation for this podcast. But one of the things that struck me most is how highly politicized the whole UPC project's been, both on a European scale, but then of course in the UK in terms of all of the fallout after the referendum. And it first struck me how politicized it was. You probably don't know this bit of the story, but Chris Mercer was president at the time, so 2015, 16. And we're in a hotel at a SEPA regional meeting, and a hotel person comes and knocks on the door and comes in and very loudly says, Mr. Davis, Mr. Mercer, yeah, I've got the Prime Minister on the phone for you. Sorry? Yeah, I've got the Prime Minister on the phone for you. So Chris and I leave the room thinking it's a bit of a joke, bit of a misunderstanding, speak to someone on the phone, and it's not the Prime Minister, it's the Prime Minister's secretary. And we thought we were going to speak to the Prime Minister. Mr. Cameron is on his way. And so David Cameron rang us to ask us the question that if I go and sign up to this UPC thing, SEPA's not going to cause me any problems, is it? So, and it's just quite extraordinary that the Prime Minister took time out of his schedule to ring little old SEPA and say, we're doing this thing. Are you going to cause me any grief if I sign up to it? And that was us thinking, that's it. It's a done deal. But of course, that was also in the build up to Mr. Cameron having a referendum, which probably politically didn't go the way a lot of us in the IP world would have liked it to go. But for the UPC project and for the UK's place in that, of course, went in a way that we almost certainly didn't want it to go. And Kevin, we were chatting just before we started recording about the webinar we did in 2017, and I've actually found the Daily Express piece. You'll be pleased to know. So I can remind you now of the headline. So we did this webinar for SEPA members about the what would be the launch of the UPC, and I think you were doing a piece on rules of procedure. And the next day, the recording of that had been leaked to UKIP, and the heading in the Daily Mail the next day was "Secret Plan to Tie Britain to EU After Brexit is Being Kept Under the Radar." And you get quoted in the piece, and it's I think he was the only UKIP MP ever, Douglas Carswell, who raised a question in the House about this awful UPC thing and how it was a secret plot to keep the UK tied into the EU. Then, of course, we had all of the shenanigans around what a post-EU agreement would look like, and eventually the decision was that the UK couldn't be part of the UPC agreement as part of that. So my question eventually is, when I get there, is this has been highly politicised, and it's left us in the position where UK patent attorneys, not unique, but probably in terms of the size of the profession, relatively unique in the UPC system, in that the UK isn't a signatory to the UPC agreement, but that UK attorneys have rights of representation through being European patent attorneys. We've been making a big thing about this at SEPA. Matt Dixon has been quoted in the press as talking about UK attorneys as being guns for hire, making us kind of like the gunslingers of the UPC world. What's your take on the UK's position in relation to the UPC and how UK patent attorneys can make the best of that?
Well, this is a big question. I'll take it in chunks. First of all, I think at the moment you're in a very ideal position because, as you say, the UK itself is not a signatory, no longer a signatory to the agreement. And that excludes most UK lawyers, barristers, and certainly excludes the UK judges. But it doesn't, of course, exclude patent attorneys in the UK, your members, SEPA. So you have the best of every world in a sense. You don't have a monopoly because, as we can talk about if you like, some UK solicitors are still working as representatives in the UPC. But all of your European patent attorneys can be representatives. And that is potentially a very significant advantage, which you should take advantage over. Now, the wider political question is also interesting. Apart from the attorneys, the profession, your members being able, should the UK become again involved in the UPC? Now, this opens up those political things you were talking about, because after Brexit, after the referendum, Boris Johnson was then Foreign Secretary, and he actually signed the instrument of ratification.
He did. Yeah.
After, and his brother, who was then in charge, who was a minister in charge of universities and science generally, was a huge supporter of the UPC. I know because I talked to him. And then suddenly you get Johnson doing his U-turn post-Brexit. And the question then was, could we still stay in? And we formed a group of solicitors, barristers, judges, and your then president, SEPA, to see whether the fact that we were no longer a signatory, no longer a member of the EU, we might still be able to continue as a contracting member state of the UPC. Now, when Johnson pulled this out, that option went. But the interesting thing politically for you and your membership, Lee, is if the Labour Party is elected and wants to get closer on certain projects with Europe, and if industry supports it, what are the prospects of re-ratifying and becoming a member? Now, I certainly won't be involved in that, but it's something that some people should be considering at least as a possibility.
It's a really interesting kind of piece of the jigsaw, isn't it? Because if a future government does want to build bridges with the EU, IP is an obvious area to do it in.
Well, and the judges would bite your hands off because the judges want to be involved. Obviously, the solicitors want to be involved. I think industry wants to be involved. I don't know, but I suspect they are. The only people who might see a disadvantage are your members, because you've got a very interesting, almost monopoly at the moment on representation from English people. Anyway, it's an interesting situation.
Well, I think our members would leap at it as well. To be very clear, I think we've realised that. I mean, given how busy we are, despite Brexit, EPO, our share has gone up. We're running, plenty of UPC cases coming out of the UK effectively. What we've learned is that even from the outside, we can do brilliantly well. So I think if we were back in, it would be even more effective. So that would be really, I think, a major positive for us. Yeah, I think we get massive buy-in, wouldn't we, really?
There's also the certainty angle, isn't there? Because one of the issues we experience the most is always having to explain these distinctions and these differences. And it's one of the areas where our major competitors, won't say which countries, but our major competitors exploit, but because there are these differences. So, yeah, I think there are lots of reasons why we would want perhaps to be in.
There will be difficulties. There will be significant difficulties because obviously the Labour government will have to accept the supremacy of EU law in this very narrow area of patent law. And there will probably have to be amendments to the UPCA, and amending an international treaty is very difficult. And then you've got the question of Italy. Italy won't be happy to give up its newly acquired central division and give it back to the UK, that's for sure. So there are enormous difficulties, but for the future of patenting and patent litigation in the UK, somebody ought to be thinking about it. And I would hope somebody would take the lead if we do get a very, how can I put it, supportive Labour government.
Lee is always thinking about it. We're all good.
And it's always good to have a hook to hang a significant issue to speak to a new government with. So you're always looking for an angle for a conversation with government. And even if this one doesn't fly for us in the short or even the medium term, I think it's a really good conversation to have. And we're already starting to get well connected with opposition leads now, but potentially government ministers of the future. So, watch this space, I think, really.
Well, let me just add that every single minister responsible for the IP portfolio was in favour of the UPC. And I did a session with your then president in the House of Lords Select Committee.
Yes. Yeah.
You remember that?
With Stephen Jones. Yeah, yeah.
Stephen Jones. And how positive were they all about the UPC? Do you remember?
Yeah, no, very much so. Yeah, yeah.
So it's not going to be easy, but if the professions want it and industry want it, then somebody should try. It won't be me, because I'll probably be somewhere else, either up there or down there.
No, you'll be enjoying the fruits of your labour somewhere. Kevin, thank you so much for taking time out of your obviously busy schedule. If you've done 4.5 hours on UPC already to speak to Gwilym and I, we normally end the podcast with some kind of tangential question. And Gwilym, I've not had a lot of time to think about one, so this is a bit rushed, okay? And I don't really know where I'm going with it.
I've got a backup. I've got a good backup one.
Oh, do you want to go with yours first? Then? Do you want to go with yours?
No, because it won't work for you or me.
Okay.
Which is, I don't think anyway. Which is, Kevin said he started 55 years ago. What were you doing 55 years ago? Doesn't work for me.
Oh, it does sort of work for me. I was 2. Dribbling a lot, maybe. Or
There we go. So I think yours is probably better. Go.
okay.
Go.
So this is spurred just by that conversation we've had about kind of things that we might want to get back quickly in terms of the relationship with the EU. So Gwilym, what do you miss most in a post-Brexit world in terms of the relationship with the EU? What would be on your list of things you would want to see again?
I sometimes have a silly answer, a nice, sensible, serious one, which is the loss of opportunity for my kids
Yeah.
to do so many fantastic things across Europe. It's horrific. So the moment that can come back, because it's just awful that their opportunities were cut off horrifically overnight, and it's just awful. There you go. It's a very sensible, grown-up answer, but it's what a shame for them.
You get second crack, Kevin. What do you want back?
No, I agree with Gwilym. I think the loss of things like Erasmus was absolutely tragic. And also the influence that the UK had on the development of IP has deteriorated. There's no doubt about that. There's no doubt about it. I mean, I'm really Aurora Arvis, the only UK lawyer who's remained involved in the preparations and the implementation of the UPC. And, frankly, it's not architect. It's because